This is Bill Hamilton at the University of Florida e-Discovery Conference at the 11th College of Law, 2016, on a beautiful, beautiful March day. And I have with me a wonderful guest panelist who's here at the conference, Judge Gill Freeman from the Circuit Court in Dade County, or Miami-Dade County, I guess you should properly say. It's wonderful to have you here. I should mention we're old friends. We started practicing at about the same time in Miami and had some, I remember, litigation battles together.
Yes.
So it's good we have an eternal recurrence here. And of course, we followed each other's careers as they progressed. So I wanted to ask you a couple questions about e-discovery. And we've been talking to some federal judges, but you've been on the state court level and actually in charge of the business court down there in Miami-Dade County. Is that correct?
That's correct. I was the first judge on the business court, so I had the pleasure of starting it and getting it rolling.
So while you were there, you must have seen some e-discovery issues blossom at that point.
Yes, and I think though now the issues were archaic based upon where we are now. We were talking about confiscating hard drives and getting experts to come and download entire computers, and we've come a long way since then.
Yeah. Well, many reasons that lawyers come to conferences such as this is to try and get a sense as to what the judges are looking for when we're in court before you. Can you give us some indication as to a good argument that a lawyer's given you on an e-discovery motion or matter that impressed you? And what was it about the lawyer's presentation that was so good that we could emulate?
Well, generally speaking, good lawyers are ones who are able to take complex issues and boil them down to very simple concepts. One thing about being a judge is that generally speaking, you've been around a long time before you go on the bench, so you're not necessarily the person who's right there with the cutting edge issues in terms of technology. Many of us are sort of in the twilights of our career, and we haven't grown up with the technology. It's not the part of our lives the way younger people have them, except if we have kids that have developed. So in approaching us and dealing with us, the best way probably is to use the concept that electronic discovery really is not significantly different in terms of the issues as regular discovery is, but the way you access it is.
It's a different information container.
Exactly.
And that presents all kinds of problems. So what is it about the attorneys that come in front of you on e-discovery issues? Is it they have a sense of the technology, they know something about this new information container, they can condense the issues down for you in a manageable way?
That's true, and generally speaking, a judge will go the discretionary way with a lawyer that they feel they can trust. The lawyer who presents him or herself as being knowledgeable, knowing what they're talking about, being reasonable, then you're more likely as a judge to make that leap of faith, as you will, in the decision-making process. So much, particularly on the trial level, is discretionary as opposed to appealable. That's what you need to recognize and deal with when you're in state court.
In state court judges, as federal judges, but even more so in state court, I think you've got a problem or an issue balancing the amount of time you have for any particular case against the issues that it may raise. And on some e-discovery issues, you probably need a little bit of education, as we all do now and then. Are you willing to make time for attorneys to come into your courtroom for longer hearings pertaining to e-discovery if they can make an argument that that's required?
I am, and one of the reasons why we created the business court was because there are so many issues that take more time than a normal trial judge has. So that's one of the reasons why we've created these more sophisticated courts, so that judges will take the time and devote it to those cases that need it. In Dade, we're also fortunate that we have a very fine general magistrate who will deal with a lot of these complex discovery issues. and to give it the time it needs.
That's Liz Swabadescent.
Yes, it is, and she's fabulous.
Yeah, she's a lovely lady, and you're very lucky to have her down there. Let's talk about the new federal rules that are coming into play. We don't have those in Florida. In Florida, we did have a new set of rules come into play. I think it was in 2012, if I'm not mistaken, that were modeled on the 2006 federal rule changes. Do you anticipate Florida catching up to the federal rules again with the new concepts related to proportionality?
Eventually, but as you well know, having served on the committee, it takes Florida a long time to make the rule changes. So yes, I anticipate we will, but I don't see it happening for probably 3 years down the road.
Let me ask you a question about diversity in the practice of law. When you and I went to law school, the gender and racial balance was a little bit different than it is now. Are you seeing more women and more minorities involved in the judicial process in Miami-Dade County than, say, 20 years ago?
Yes, in the judicial practice, we really have been fortunate in that 2 of our last 3 governors really made an effort at diversity in terms of their appointments. I don't think the last governor has been doing that as much, but we've come a long way. At least in Dade now, half the judges are women.
Wonderful.
So yes, that's a major improvement over time. The electorate also has been a little bit more aware and has been better at electing a diverse judicial population.
Well, we're doing what we can here at the 11th College of Law to enhance the pipeline, if you will. We're hoping more and more women and minorities get into e-discovery as well, which some of us believe is the front lines of the upcoming struggle for justice.
And I know that your panel has been quite diverse, and believe me, I took notice of that there were, women included as panelists, and that was significant. I'm not seeing as much in terms of the sophisticated litigation having women as lead counsel, and that's a little bit troubling. There aren't enough women and minorities taking lead positions in the major cases.
Well, that's a task ahead of us.
Yes, it is.
This is Bill Hamilton and Judge Gill Freeman at the University of Florida E-Discovery Conference at the 11th College of Law, March 2016.